But then I just saw it was just a bunch of stuff on like curfews.
Yeah,
I'm starting to wonder about that for like the night class. Like, how long do they go?
no, it's only for it's only for restaurants.
Oh, the restaurant. I thought it was for all like.
No, just restaurants. They have to shut down at 9:30 apparently.
Drinking and all.
There you go. There you go.
Yeah. Also, they did block Jersey and Connecticut.
Did they?
Yeah, I remember they added those to the list.
Jersey and Connecticut had done so well. Hello, everyone. Can you hear me at home? Okay.
They would go for the higher population.
All right. Let's talk about a couple of administrative things. We had a faculty meeting yesterday, and it came to my attention that you guys, a lot of you are taking an assessment test on the 19th, which is 3 days, December 19th, which is 3 days before our final. And the administration has decided to leave that on. I know that's not the best of situations for you guys. They had decided that since you'd be studying for con law anyways, that having it would not be a big deal before the final exam. So unfortunately, that is going to be on the 19th, and then our final will be on the 22nd. Both of them will be taken remotely. I don't believe students are allowed in the building after November 17th, right? And our plans will remain the same. The first,
Sorry.
that's okay. The first test, the so-called major test, is going to be on the Tuesday before Thanksgiving, which I believe is November 24th. And that is going to cover the materials of classes 1 through 16. That is a little bit more than half of the class. I'm planning on both tests being an hour and a half, but I might make them 2 hours just to give you extra time. A question? Well, they were talking about December 19th.
On it, if you look on downstairs on the stairs, just scribbled it off and changed it tonight. Written in pen.
Okay. I don't know why that is. I don't control the assessment test. So, you know, they were talking of it as it was as if it were the 19th. In the past, and I'm further confused by it, to be honest, because in the past, it has always been on the very last day of finals, so as not to conflict with others. I'm guessing that maybe Themis had some reason for moving it up, and that there was no choice on that. There is a makeup, by the way, for the assessment test in January. So, you know, you can plan to take it in January if you think that it's going to cut into your studying too much for the final here. All right, so our test, once again, the first little bit more than half of the course will be like one class more than half of the course will be tested on November 24th, which is the Tuesday before Thanksgiving. And that will count 35% of your grade. And then the final, that's classes 1 through 16. And then classes 17 through the end will count for the remaining classes. The exam on the 20, what is that, the 22nd? Is that what we said? Yeah. December 22nd will be classes 17 through the end of the semester. I think we'll be getting about 28 classes in. I'm supposed to have 30, but I think we'll be getting about 28 classes in. And we're in good shape for finishing all the material that we need to finish, okay? And again, that will count for 35%. So the two exams together will count for 70%, and the quizzes will count for 30% of your final exams, okay? All right, let's continue with First Amendment. We were doing the prior restraints stuff in the last class. And the biggest effect that prior restraints has these days is in regard to licensing. And the reason that licensing is such a big deal is because under the police power, governments, um, uh, are trying to protect consumers, try and protect people with health, safety, and welfare. And very often licensing is part of that scheme. So for example, every March, I am required to register with the Board of Bar Overseers because attorneys represent clients. And if they act unethically in regard to clients, they can do a lot of damage to clients. So there is a licensing scheme that is required for lawyers. And the same applies to doctors, and the same applies to a whole bunch of different things. Most of the time, however, we're going to see licensing in the context of public speech, public demonstrations, public proselytizing by religious groups, marching, assembling, things like that. The government obviously has a vital role in ensuring people's safety. So, for example, what has been happening in regard to the Black Lives Matter protests is that there's been counter protests that have been occurring as well. And the fear is that there's going to be violence and property damage. And so, when there's two groups who are on opposite sides of the issues, the government usually doesn't want them assembling in the same place. And often they will try to control that through a licensing scheme of some sort. So you have to balance that against the danger of prior restraints, because prior restraints can be used as a form of censorship. So if, for example, the licensing scheme sets a licensing fee that is way too high, then it's going to chill speech. Well, I don't think I'm going to go and protest if you're going to charge me $1,000 to get a license to be able to go down and do my protest type thing. Furthermore, the government, may ask you some questions as to what kind of speech you're going to engage in. And it can be claimed that that's another form of censorship as well. So the courts, tread fairly lightly through these, recognizing that there's justifications on both sides of the issue. So I haven't given you the standards yet. I guess I'm doing a couple of cases before. Well, I'll tell you this. Licensing as a prior restraint will be allowed when the government sets clear, comprehensive standards that leave almost no discretion to the issuing authority. I'll be giving you more information on this a little bit later on, okay? It's a little bit more detailed, but this is sort of telling you where we're going to be going. And so the idea here is if you take discretion out of the hands of the licensing authorities, then they cannot act in an arbitrary way in favor of one form of speech over another. So our first case, pretty straightforward case, Lovell versus the city of Griffin, Georgia. Here we have an ordinance that in order to disseminate literature in the town of Griffin, Georgia, you have to get permission from the city manager. And that's the extent of the law. Do you guys see that the city manager will therefore have a lot of discretion when it comes to issuing licenses? And the court says, yeah, this is a big problem, especially when the city manager refuses to issue a license to Lovell. Jehovah's Witnesses actually don't seek out licenses. They believe, we'll see this in some of the cases that come forward. First of all, when it comes to free speech, you're going to see that Jehovah's Witnesses are about the most discriminated against group of people, at least at the Supreme Court level, of anyone. Towns and cities are often trying to prevent them from proselytizing. Not only do they believe that proselytizing is a important tenet of their religion, they also believe, and we'll see why later on when we do the Barnett case later on in this class, I believe we'll get to Barnett. They also believe that even requesting the license is against their religious beliefs. They essentially, and I'm probably oversimplifying this, and I apologize if I'm not quite getting it right. They essentially believe that they're answerable to God, and that subjecting themselves to man's laws instead of God's laws would violate their religious beliefs. So here, because this it's just, too broad, too open-ended, too much discretion in the city manager, the Supreme Court, even back in 1938, calls this unconstitutional. It is essentially a system of censorship. A little trickier case is a more recent one, the Watchtower Bible and Tract Society of New York, Inc. versus the City of Stratton case. This is a upstate New York case. So Stratton has an ordinance. It makes it a misdemeanor to engage in door-to-door advocacy of any type without first registering with the mayor and receiving a permit. Once again, a Jehovah's Witness is prosecuted because they do tend to proselytize door to door. The court strikes this down as being unconstitutional. It says it's a prior restraint. The court does recognize that the town does have an interest in regulating solicitation activities. Says what we know is going to happen, that the police power interest of the town has to be balanced against the First Amendment rights of the people. The village is issuing the following goals that it's trying to achieve in requiring the licensing scheme. One is to protect against fraud, two, to prevent crime, and third, to protect the privacy of residents. The court concedes that these are important rights. But what the court finds offensive here is the notion that the citizens have to go to the town and inform the government that it plans to speak to neighbors in order to and get a permit in order to do so. The court is a little bit worried about the overbreadth of this type of law. I mean, I suppose that technically, if I went over to visit a neighbor, going door to door to visit a neighbor, and started talking about politics or religion, I might come within the ambit of this type of law. The court is very careful about expression or regulations that chill expression of religious or unpatriotic speech. So it acknowledges that Jehovah's Witnesses don't even believe that applying for the license is proper. Chief Justice Rehnquist issued a dissent and made note of, I remember this case very well, the couple of Dartmouth professors who were murdered in just outside of Hanover, New Hampshire. I believe their last name were the Zantops. This is a horrible, horrible case. A couple of local teenage high school boys decided that they wanted to kill someone. And so they started going from house to house and knocking on doors and pretending that their plan was to pretend that they were doing a survey as a high school assignment on environmental questions. And they would question people in their homes and then they carried knives with them, and they would then just kill them in their homes. They attempted to do it on several occasions previous to this one. In some houses, they even cut some telephone lines in preparation. They mainly failed before this one because no one was home. Unfortunately, the Zantops were home. Because they were used to engaging with young people in the college setting, they invited them in. And of course, they were brutally stabbed to death. They did catch the kids, and the kids, I think one of them sort of ratted out the other. I think one of them got a life sentence. I think they were tried as adults. They were like 17 years old. And this is what Rehnquist is saying, maybe if they had been required to apply for a permit and all the residents knew that they shouldn't let anyone in unless they could show some type of a permit, that they wouldn't have been given access to the house and the murders might not have occurred. He says this is essentially a time, place, and manner restriction. The ordinance is content neutral. It doesn't regulate the subject matter or the viewpoint. It regulates the manner by which one can canvass, first get a permit. It would, he believed, have some deterrent effect on criminal activity. Here are the standards when you get a licensing question in regard to prior restraints. The license laws are constitutional only if, one, the government has an important reason for licensing. This is always a police power reason, health, safety, welfare, and the like, or consumer protection is part of health, safety, and welfare. Two, there are clear standards that leave almost no discretion to the licensing authority. Usually the best of these say that you can only license the time of the leafleting or of the protests or the speech on public grounds. But you essentially have to allow the speech to go forward in some way. Three, there are procedural safeguards allowing for prompt determinations, full and fair hearings, and prompt judicial review before speech may be concluded, okay? Now, I do spend a lot more time in First Amendment law on this whole prior restraint stuff and this whole licensing stuff as well. The problem, with doing First Amendment law in a survey class is that I have to go through this material fairly quickly, and we don't get to cover all of the cases that are out there. Okay, the next question is the question of so-called compelled speech. This is essentially the right not to engage in speech that the government wants you to engage in, okay? So, for example, if the government passed a law saying that when the national anthem played at a sporting event, everyone was required to stand and to sing the national anthem, that would be a form of compelled speech. It would prohibit Colin Kaepernick from doing what he did, which was take a knee, number one. And number two, it would make you sing the song along with, everyone else in the stadium. Even if you didn't want to sing the song, you would be compelled to do so under some form of penalty. That's a fairly easy, scenario. The right to refrain from speech is a corollary of the right to speak, right? So just as the government can't prevent me from speaking in most cases, it also can't force me to speak a message I don't want to say. The two concepts go hand in hand. The big case, the one that you'll probably always remember, is the West Virginia State Board of Education versus Barnett. Please notice the year of this case, what was going on in 1943. World War II was going on in 1943. Obviously, we had a really heightened sense of patriotism at the time. It was a life or death struggle for democracy, worldwide democracy. and the continued existence of the country. So West Virginia had does anyone here remember the flag salutes? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
I remember that from when I
We
was itty
said it in
bitty.
school every morning, right? I grew
Yes,
up
we
saying
had
it
to
in
do
school
that.
every morning as well.
I don't know
The
if I
funny
could do
thing
it
is,
now.
is that I thought, you know how sometimes this happened to me when I was in church as well as a kid. You think the words are different words because you just learn them by hearing them. So I used to think it was, I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation. I used to think it said under guard instead of under God. And I thought that indivisible was invisible as a little boy. So you know, I was like repeating some of the words I repeated were incorrect. I don't know if you know this, the words under God were not originally in the flag salute. They were added in the mid 1950s during the Red Scare. So before that, the Barnett boys involved in this case would not have been saying under God. Um, um, uh, and just those words would have been left out. It was the exact same flag salute. So West Virginia required that all teachers and pupils in public schools be required to participate in the flag salute. And that failure to do so for the students would lead to an expulsion from school. And if a student was expelled from school, he or she could only come back by agreeing to participate in the flag salute. And on top of that, the child's parents would be prosecuted for juvenile delinquency for not sending their kids to school, and literally could have been put into jail for 30 days and charged a fine. The Barnett boys they weren't twins, but they were close in age, and they were fairly young, and they were members of the Jehovah's Witness faith. And they believe, for the reasons that I've put on this slide, this is not in the version of the case in your case book, but I thought you might be interested in seeing why. They essentially believed that saluting the flag was praying to a false idol. They took that out of Exodus, thou shalt not make unto thee any graven image or any likeness of anything that is in heaven above, or that is in the earth beneath, or that is in the water under the earth. Thou shalt not bow down thyself to them, nor serve them. So they considered the flag to be an image, they thought it was contrary to their religious beliefs. If they thought it was contrary to their religious beliefs, it was contrary to their religious beliefs. And so they refused to do the flag salute and they were expelled. And you know where the case ended up. They all end up at the Supreme Court eventually. Now, a couple of years earlier, the Supreme Court had decided this Minersville School District versus Gobitis case, which was essentially the exact same case. It involved Jehovah's Witnesses. It involved the flag salute and the like. In that case, the Supreme Court decided to uphold the law, saying that it was not unconstitutional. And the justice who wrote the majority opinion was a guy named Felix Frankfurter. Um, just a couple of years later, the court changed its opinion fairly decisively, and this time in a 6-3 decision, overruled Minersville and held that compelling public school children to salute the flag was unconstitutional. You are compelling them to utter a form of speech they wished not to utter. Justice Robert Jackson wrote the majority opinion. He tended to write in very flowery language, kind of beautiful language, quite frankly, if not a little bit formalistic and unapproachable, at least to the modern reader. If there is any fixed star in our constitutional constellation, it is that no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion or force citizens to confess by word or act their faith therein. Felix Frankfurter wrote a very bitter dissent to the case, which expressed his opinion of judicial minimalism. I think I've told you already that Frankfurter was a very politically liberal member of the Roosevelt administration. He was a close advisor to FDR. He was an immigrant as a young child from Austria. He was raised Jewish, and his opinion essentially said, you know, I am a member of the most discriminated against and victimized group in world history and civilization. I don't think that anyone should be forced to do the flag salute. But that is not for the court to decide. That is for the legislatures to decide. And his big belief was that the legislature was answerable to the people. So except in extreme cases, you would defer to the legislature. That's, you know, that's the Barnett case. I think most people today would agree with the majority in this case, that someone who sincerely had reasons not to do the flag salute should be excused from not doing so. To this day, there is no requirement that children engage in the flag salute. I did, and I think many of us did when we were young kids, and perhaps even throughout high school, but the school was technically not allowed to force you to do so. Another, I know I have a bunch of people from New Hampshire, so this case should be near and dear to your hearts. Woolley versus Maynard. And it involves the New Hampshire license plate, live free or die. At the time, in the 1970s, New Hampshire had a law that said all non-commercial vehicles must bear the state motto, live free or die. George Maynard and his wife drove two cars, and both of them covered the words live free or die on their license plates. They were Jehovah's Witnesses, and they believed this was contrary to their religious beliefs. They also believed it was contrary to their political beliefs as well. I guess what Maynard did was he left the words live free, but he took the words or die and covered them up on the license plate. He got stopped once, was given a warning, got stopped the second time, and then was literally, arrested and put into jail as a result of covering the logo. He claimed this was compelled speech. He was being forced to put the state motto on his automobile, and the Supreme Court agreed with him. New Hampshire could not constitutionally require citizens to display the state motto upon their license plates. Essentially, the state was requiring these individuals to use their own private property as a mobile billboard for the state's ideological message. They viewed this similar to, being required to salute the flag. You're being required to recite the state motto. There's a right of individuals to hold a point of view different from the majority and to refuse to foster an idea that they find morally objectionable. The dissent said, once again, that the license plate was government speech, not private speech, because the license plate was owned by the government, even though it was affixed to the car. The majority said, it doesn't matter, you're still being compelled. I think this is the difference between this case and the Walker case, the Confederate flag case, which is similar results, but which is here, in Walker, the Sons of Confederate Veterans wanted to voluntarily put their own message on government property. Here, Maynard was forced to put a government message on his own property. And that's what the court found to be objectionable. Relatively new case. Go ahead, Teddy.
Whose property is the license plate?
I think in most states, the license plate itself belongs to the state. It does not belong to the individual. And, you know, licensing requires you for identification purposes, obviously, to affix the plate to your property. So it's on, you know, the property that you own. And what distinguished this from Walker was that not who owned it. Here, it wasn't so much who owned the license plate. It was Maynard being forced to convey a message he did not wish to convey. So it was so-called compelled speech. There was no compelled speech in the Walker case because the sons wanted to put that message up. But the government said, no, we don't want that message associated with us, essentially, okay? National Federation of Family and Life Advocates versus Becerra. We are going to, just as a warning, it's a flash point issue. We are going to, you know, be talking about abortion quite a bit throughout the rest of the semester. A couple of times today, and obviously when we get into fundamental rights, we'll be talking about abortion as part of the right of privacy as well, okay? So again, you know, I'm just going to suggest that we keep our political or religious perspectives out of this, and we'll just examine it as a matter of law as we go forward, okay? So here, the California Reproductive Freedom, Accountability, Comprehensive Care and Transparency Act. I wish they would just get nice, short, sweet names that don't need acronyms. They called it the FACT Act. How do you like that? That's a mouthful, huh? The FACT Act. It was enacted to regulate crisis pregnancy centers. Crisis pregnancy centers are pro-life centers that offer pregnancy-related services, but that come at it from a perspective that is opposed to abortion. This FACT Act, however, required the clinics to put up in noticeable ways certain notices. Now, there's two types of clinics. There are licensed clinics and there are unlicensed clinics. The licensed clinics will obviously have medical professionals working for them, whereas the unlicensed clinics will not. For the licensed clinic, the clinic had to put up the following statement. California has public programs that provide immediate, free, and low-cost access to comprehensive family planning services, including all FDA-approved methods of contraception, prenatal care, and abortion for eligible women. To determine whether you qualify, contact the county social services office at, and then, you know, they put the phone number in. And this must be posted so that it can be understood in several languages and also in a conspicuous place. For the unlicensed facilities, they were required to display in a conspicuous place the following statement. This facility is not licensed as a medical facility by the state of California and has no licensed medical provider who provides or directly supervises the provision of services. So obviously the unlicensed places didn't like the fact that they were required to advertise that they were unlicensed and had no licensed medical providers. Both a licensed provider and an unlicensed provider sued, saying this is compelled speech. We are being forced to display a message that we don't want to display. The government, just like it is in Barnett, is making us convey a governmental message. And we don't think that we should have to do it, like in Barnett in Woolley versus Maynard. The court disagreed. The court said this was not compelled speech. Justice Thomas wrote the opinion. He said that this is content-based speech. There is a particular government message that they are compelled to present. Therefore, it is subject to strict scrutiny. And whether there is a compelling interest to notify women that they have a right to an abortion, or if you're unlicensed, to notify them that you're unlicensed, he says this is wildly under-inclusive. It is only these pro-life centers that are required to put up the message, and not the centers that will actually provide abortions or take the opposite opinion. And so this was stricken as being unconstitutional. Breyer wrote the dissent. He referred to a case that we're going to talk about later on, which provides the current standard for abortion, the so-called undue burden standard, but he's referring to it in a different way here. This is Planned Parenthood of Southeastern Pennsylvania versus Casey. This provides the current law on the right to an abortion, okay? Now, in that one, there were a couple of different things that the Pennsylvania law required. Number one, if you are a married woman and you wanted to get an abortion, the Pennsylvania law required you to inform your husband before you got the abortion. The Casey decision struck that down as violating the undue burden standard. Second thing it required, if you were under 18 years of age, you had to get your parents' permission in order to have the abortion. And Casey also struck that down, saying that there had to be a judicial opt-out, that the child could either seek the permission of the parents or get a judge to okay it. Then there was a relatively short waiting period that the Supreme Court decided was okay. So you would have to go to the clinic. They couldn't do the abortion on the spot. They would have to send you home, and you would have to come back a couple of days later. And then finally, the one that matters here is that Pennsylvania required the abortion clinic to give information to the woman, telling her about the ability and the availability of adoption services rather than abortion services. And this is what Breyer is griping about. That was upheld as being constitutional. So doctors could be forced, under the Casey case, be forced to inform women that they also had the right to seek adoption services. And what he's saying here, his argument essentially comes down to, what is sauce for the goose is normally sauce for the gander. If you can make doctors who would perform an abortion say that you can also do adoption, then why is it okay not to force doctors to say the opposite, which is an abortion is also available to you as well? So that's the sort of back and forth between the majority and minority in that case. I think this is our final compelled speech case. Yep, it is. Rumsfeld versus, this is called Fair Forum for Academic and Institutional Rights, Inc. It is essentially, for lack of a better word, it's an association of law professors. Sort of a union for law professors, we'll say. And what set this case up is the don't ask, don't tell policy that the Clinton administration put forth. Up until President Clinton was the president, if the one of the military services found that you were homosexual, it would dishonorably discharge you from the military. What Clinton did was, by executive order, he passed the don't ask, don't tell. It's not a dischargeable offense for you to be gay. and be in the military as long as you don't tell anybody about it. So you sort of have to stay in the closet, essentially, keep your mouth shut. And then they can't discharge you if they find out that you are in fact gay. Law professors and lawyers don't tend to be a liberal bunch. They tend to run the political gamut. I think it's fair to say that educators in general tend to be more liberal. And law professors tend to be more liberal than lawyers in general, even though most law professors are lawyers. They found this to be discriminatory. And so they, through collective bargaining, essentially, would force their law schools to prevent military recruiting at the law schools. It's done very differently today, but when I went to law school, I graduated in 1981. Prospective employers came right onto campus to interview you. I did many interviews right on campus. I had a lot of friends who went into the JAG Corps, the Judge Advocate General Corps, of the various branches of the military. And those branches would come right onto campus and recruit, okay? Just like big law firms would come onto campus and recruit, and governmental agencies would come onto campus and recruit. So a lot of the law schools, enough of them to gain the attention of Congress, banned military recruiting at the law schools on the ground that it disagreed with the don't ask, don't tell policy, which the law professors found to be discriminatory. Congress passed the so-called Solomon Amendment, which we've talked about tax and spend, and we understand that the government can spend money, can give grants, can give aid to educational institutions, but can also attach conditions to them, right? So this should look really familiar to you as being right under the taxing and spending power of the government. The Solomon Amendment says, we are going to withhold a portion of your federal monies if you don't allow military recruiting at your law school. And so FAIR challenged this, claiming it was compelled speech. You're forcing us to allow military recruiting. You're forcing us to provide a government message. Is that someone upstairs dragging stuff around, or is it that noise coming from somewhere else? I don't know. I don't know if you guys can hear it at home, but this
Thunder, it's gonna snow.
sounds like it's coming from the third floor, essentially. So in any event, let's pretend we don't hear it. Yeah, that's where they take the dead students who have offended the administration up to the third floor, essentially. Yeah, the ones who feel con law are up to the third floor.
There's a pool
Yeah,
up
so
there
there
in
you
nice
go.
weather.
So they claim that this is compelled speech, and they're being forced to give the government message, of allowing military recruiting on campus. Chief Justice Roberts writes the opinion. He says, no, this is not speech that is going to be deemed attributable to the law professors. All you're required to do is make rooms available. You're required to perhaps send out some emails announcing that they're going to be present. You might be required to hang up a couple of announcements on bulletin boards throughout the law school. But you're still free to go out and say that you disagree with don't ask, don't tell. You can tell all your students that you disagree with don't ask, don't tell if you want. No one is going to think that this is your message coming. This is not the government dictating content. And the court essentially said, this is essentially a time, place, and manner imposition. You're not being told what content that you have to say. You don't have to endorse the speech, but you have to facilitate the speech, so to speak, okay? The question here is, in the last couple of cases, is the court moving away a little bit from the Barnett case and the Woolley case? And as always, the answer is we don't know. Are these just limited exceptions, distinctions that are meaningful? Or is the court going to keep going in a further direction to get rid of the compelled speech prohibition? And we don't know. Okay. All right. Now, next topic that we have to talk about is the right to speak anonymously. Is there a right to speak anonymously? And once again, we can find guidance in the history of the Revolutionary War and the creating of our Constitution. So you guys understand that because, talking about prior restraints, we had already mentioned that the British government essentially censored American speech that they found to be inflammatory and rebellious. A lot of anti-tax speech. They taxed American speech. So very often what that would lead to is, American patriots who would become, opposing the British government eventually, would put up anonymous broadsides, excoriating the way the government was taxing or treating the Americans, and hanging them in a public place with some pseudonym in them. And then what this led to was, after the Constitution was written by the Constitutional Convention in 1787, it had to be sent out to the states for ratification. 9 of the 13 states would have to ratify the Constitution, agree to accept the United States Constitution. At the end of the Constitutional Convention, it was not a given that the Constitution was going to be ratified. Okay, there was a big political debate. So a lot of people who were at the Constitutional Convention ended up writing what we would today call op-ed pieces in newspapers. They would put opinion pieces in newspapers advocating for the ratification of the Constitution, talking about the various parts of the Constitution and what it meant and why it was good for the country. Today, we know these papers as the Federalist Papers. The Federalist Papers were written by Alexander Hamilton, James Madison, and John Jay. Although Hamilton and Madison wrote the great bulk of them, Jay wrote a couple of them, okay? Except Alexander Hamilton was hated by Thomas Jefferson because Alexander Hamilton was a Federalist and Thomas Jefferson was an anti-Federalist. And it's kind of like the presidential election that we're dealing with today. You hear the name Trump or you hear the name Biden, and half of the country is going to feel sick to their stomach, right? It's the person who delivers the message over the message itself to some people. And so what Hamilton and Madison and John Jay did was they used a pseudonym to publish the Federalist Papers. And all 3 of them became known to the public as Publius, P-U-B-L-I-U-S. That's how all of them were signed. Now, people who are opposed to the ratification of the Constitution wrote the so-called anti-Federalist Papers. They were a little bit more creative in their names. They didn't all have the same name, but they would adopt, either characters from Greek literature or Greek philosophers. So you'd see, an anti-Federalist paper named Cicero, or something like that. And so why do I give you this history lesson? Is to remember that, the Constitution is part of the history of the country. Its culture and fabric is a reflection of the history of the country. And so the Supreme Court is going to interpret the Constitution as a reflection of the history of the country. And it's going to protect, to at least some degree, the right to speak anonymously. Also, as you probably know, a lot of authors over the years have taken pseudonyms themselves, right? So for example, I wish I could remember all of these. There was a French author named Georges Sand. Georges, Sand. A male name, and I forget what her real name was, but she took a man's name so that she could get her material published back in the 1700s, before obviously there were equal rights in France. George Orwell is not the author's real name. If you like spy stories, John Le Carre is a dude named Simon Cromwell is his real name, okay? So over the years, a lot of people have chosen to write and speak anonymously. Teddy? Benjamin Franklin? Yeah, so Benjamin Franklin used pseudonyms as well. Even some rock bands have used pseudonyms, right? My generation, I'll see how old you folks are. Anyone know who Derek and the Dominoes was? That was Eric Clapton, who decided to create a pseudonym for the band. So this happens occasionally. So we come to this McIntyre versus Ohio Elections Commission case. This is such a reflection of local government. It's unbelievable. When you're young and you have young kids and you go to town meetings, you want the town to spend on the schools, because you want the schools to be as good as they could be, because you want your kids to get into a good college. But then when you become elderly and the kids have moved out of the house and you're on a fixed income, you go to your town meetings and you say, don't spend, don't spend, don't spend. The schools don't need any more money. I'm on a fixed income. I can't afford higher taxes. And if anyone has ever been to a town meeting, they see this, all the time at town meetings. And I'm guessing that this case is a reflection of this. There's an Ohio law that prohibits the distribution of anonymous campaign literature. McIntyre created these leaflets, distributed them. She was opposed to a school tax levy that was before the voters. And the leaflets were signed by concerned parents and taxpayers. Someone obviously ratted her out, and she was discovered and charged with violating the Ohio elections law. She appealed, went up to the Supreme Court. In the Supreme Court, I think we've set this up already. Anonymous books, leaflets, and handbills have played an important role in the progress of mankind. Anonymity is motivated by a fear of governmental retaliation and is an aspect of free speech that is protected. We don't have the time to go into it in a lot of detail, but there are exceptions to this. So for example, there's a Supreme Court case that involves, have you guys ever had somebody in front of a supermarket or somewhere in public ask you to sign a petition to get it on a ballot? You have to have a certain number of signatures, or to sign not a petition, but to sign in favor of putting a certain person on a ballot for an elected position. Those petitions generally become public documents. They have to verify that you are in fact, a registered voter and that you are who you say you are. A lot of people put phony names on those things. They think it's funny, but all of them have to be verified. And the Supreme Court said that those can be considered to be public documents, and the government is required to share that information with people who properly request it, and the like. So this is certainly not, the right to be anonymous is certainly not an absolute right, but there is a general right to speak anonymously, okay? The unconstitutional conditions doctrine, and we'll take a quick waltz through this as well before we get into, we're going to start unprotected speech in a short bit. The unconstitutional conditions doctrine says, look, even when the government is not required to give you a benefit, if it threatens to withhold the benefit unless you give up a constitutional right, then it is unconstitutional, okay? So if the government says to you, you have to engage in compelled speech, you have to do the flag salute, or you don't get this tax abatement. You have to do the flag salute, or you can't deduct, you can't get your child deduction on your state tax return, okay? Something like that. That would violate the unconstitutional conditions doctrine. Even though the government can come back and say, we don't have to give him that benefit, it's still quelling free speech. Because if it gives everyone who agrees to give up the constitutional right the benefit, but not the person who doesn't, it is quelling that person's free speech, okay? So the case that shows it fairly clearly is the Spicer versus Randall case. State of California gave real estate tax exemptions to veterans. And at this point, probably most of the veterans would have been either World War II or Korean veterans. And then all of a sudden, after just, all you had to do was show that you were a veteran, give proof that you had served the country. All of a sudden, they started requiring you to take a loyalty oath in order to get the benefit. You had to take an oath that you do not advocate the overthrow of the federal or state government by force, violence, or other unlawful means, or advocate the support of a foreign government against the United States in the event of hostilities. This was sort of towards the end of the so-called Second Red Scare, the 1950s, late 1940s and early-ish 1950s were the Second Red Scare in the United States. We were deathly afraid the communists were trying to take over the country. The first Red Scare was following the Bolshevik Revolution in 1917. So the first Red Scare was mostly in the 1920s. And you saw during the 1950s, the House, oh geez, I'm having a senior moment and not, Un-American Activities Committee. The House Un-American Activities Committee, where they would investigate, whether certain governmental employees had once been members of the Communist Party. And the famous question that was asked is, are you now or have you ever been a member of the Communist Party? And a lot of people would refuse to answer that. And people got blacklisted and the like as a result of that. So in any event, Spicer challenges this. It goes up to the Supreme Court. The Supreme Court says this violates the unconstitutional conditions doctrine. To deny an exemption to claimants who engage in certain forms of speech, and here it's the refusal to engage in compelled speech. See how these are not mutually exclusive, they can go hand in hand. I can give you both an unconstitutional conditions issue and a compelled speech issue in the same fact pattern, right? Is to penalize them for such speech. Its deterrent effect is the same as if the state were to fine them for this speech. The denial of a tax exemption for engaging in certain speech necessarily will have the effect of coercing the claimants to refrain from the proscribed speech. The denial is frankly aimed at the suppression of dangerous ideas. Same result in Reagan versus taxation with representation. You guys know that Donald Reagan was not Ronald Reagan, although Donald Reagan served in the Ronald Reagan administration. Ronald Reagan was obviously the president. Donald Reagan was the Secretary of the Treasury for at least part of the Reagan administration. Those of you who have ever been involved in a nonprofit enterprise, I had the distinction of being president of the Andover Little League for 3 years. I can tell you it was the worst 3 years of my life. At least my wife thought it was the worst 3 years of our married life. It was horrible. Parents are unreasonable, especially in affluent towns. They all think that their children are going to be professional baseball players. And it's funny, I can't remember how many times I would say to them, well, let me ask you a question. Are you able to afford a house in Andover? Because you were a professional athlete? And they say, no, I stunk at sports. And I would say to them, what makes you think you got here because of your brain, right? You're well educated and you got a good job and you earn money that way. Yeah. Well, what makes you think that your child inherited the sports gene if you don't have it? And that usually shut them up fairly quickly. Yeah, exactly, exactly. So, um, and I also had the benefit. We have 3 boys, one of whom was a superior athlete and then ended up playing college baseball. One of whom was an average athlete, and one of whom is a special needs son who played challenger baseball. So I could get to say that I have kids at every level of sports. And the goal is to have a place for all of them, not just the elite ones, so to speak. So in any event, I digress. Let me come back. What you learn is when you're involved in a charitable activity, you want people to donate money to that activity. So you register your organization as a 501c3 organization, which means that if people donate to your charity, they can deduct the charitable donation from their federal income taxes. And a lot of people won't give money unless they can deduct it from their charitable income taxes. But in order to get 501c3 status, you have to agree that you won't engage in political activity, okay? Because remember, when you're not, and the other advantage of 501c3 status is you don't have to pay any income taxes on revenue that you raise. You just have to devote it to the charitable cause, okay? So the government obviously recognizes, the IRS recognizes that if it ain't collecting taxes from you, it is in a way subsidizing you because you're not paying the taxes, okay? And this falls into unconstitutional conditions because it's a benefit to be immune from the taxes, just like it was with Spicer. The government is giving you a benefit of not making you pay taxes, but you just have to promise that you won't use the association for political purposes. The government doesn't want to subsidize political campaigns, essentially. So that's what happens here. You get these 2 nonprofit groups, they merge. Prior to their merging, one of the groups was a lobbying group. It lobbied for certain activities. The other one was a pure charitable group that had 501c3 status. Once they merged, the IRS took away their 501c3 status because now part of their activities was political lobbying. And so they claimed you're violating the unconstitutional conditions doctrine. We're trying to engage in free speech. Lobbying is free speech, and you're violating our ability to do this. The court says no. All that's going on here is the government is choosing what it wants to spend its money on. If it doesn't want to spend its money on subsidizing political campaigns, it doesn't have to. You can go right out and you can disassociate the 2 organizations and have the one that was purely charitable get its 501c3 exemption again. And the one that wants to do lobbying, knowing that it's not going to get a 501c3 exemption, can go and do that. But you decided to merge them together. You live with the consequences, essentially. And then this was extended in Russ versus Sullivan. What we will see essentially is, I'll bottom line this for you. What we will see essentially is that there is a constitutional right for a woman to have an abortion in this country, okay? The right was created by Roe versus Wade. It was created as a fundamental right. Over the years, the right has been watered down a bit. I already told you that the current standard is in the Casey case. The standard now is the so-called undue burden standard, which arguably is not a fundamental right standard. But the bottom line is there is a constitutional right to an abortion. However, there is not a constitutional right to have your government pay for an abortion. And over the years, Congress has passed laws that say that, public assistance money cannot be spent on abortions. Federal public assistance money cannot be spent on abortions. And also setting up rules for healthcare clinics that get federal funds, how they have to be operated in order for them to get federal funds if abortions are performed. And obviously the biggest organization that comes to mind is Planned Parenthood, right? And so this case essentially applies to Planned Parenthood as well as other similarly situated health facilities. So this is so-called Title 10. It provides for federal funding for family planning services. However, HHS has issued regulations limiting the ability of Title 10 funds recipients to engage in abortion-related activities. So here are the requirements here. Number one is none of the funds can be spent on counseling concerning abortion as a method of family planning. Number two, the clinic is not allowed to encourage, promote, or advocate abortion. Number three, Title 10 projects must be physically and financially separate from prohibited abortion activities. And I know that Planned Parenthood had done this, is literally, you would have to put a wall between part of the operation that performed abortions and the rest of the operation that just engaged in family planning services. The big one that seems to be at issue here is the no encouragement, promotion, or advocacy of abortion. You don't get your money unless you don't talk about abortion, okay? So this is obviously a restriction on the ability of these organizations to engage in free speech. And that is what's challenged here. And the court looks at this in the exact same way as it looked at Regan versus taxation with representation. It said, no, we are not prohibiting you from engaging in certain speech. We are just telling you that we don't want to spend money, the government doesn't want to spend money on certain activity. And if the government doesn't want to spend public money on advocating for abortions, then it doesn't have to, regardless of what your viewpoint may be. The use of public subsidies by the government was not rendered discriminatory simply by the government's favoring one viewpoint over another. Do you see how this, in a way, is analogous to the Sumum case that we had talked about previously, where the government doesn't have to convey a message it may disagree with? And here, the government doesn't have to give you money for you to convey a message that it disagrees with. But the court went in a different direction in Legal Services Corporation versus Velasquez. Legal services corporations are, essentially legal services lawyers. When you start to practice, you may become a legal services lawyer, and if not, you're going to run into them. You're going to run into them in criminal law cases. You're going to run into them in landlord-tenant cases. A lot of people who are indigent are represented by legal services attorneys. The Legal Services Corporation is a national corporation. It receives federal money. It is authorized to distribute funds to local organizations which provide free legal assistance to indigent clients. And in this particular case, indigent clients who are making claims under welfare cases. Congress goes and passes this act, the Omnibus Consolidation Rescissions and Appropriations Act of 1996. Do you think Congress thinks that the more fancy sounding and unpronounceable the act is, the better the act is? I mean, some of these names for these acts are just, really incredible.
They usually try to keep them near the opposite effect.
The opposite of what the act is supposed to be accomplishing. Yeah. So here they actually say that a lawyer who is working from an organization that is funded by the Legal Services Corporation is not allowed to seek to amend or challenge an existing welfare law, even if the claim is that it is unconstitutional. Okay. So if you're a lawyer and you're representing a client, and all of a sudden in the middle of a case, it strikes you that the law that your client is not getting any benefit from is unconstitutional, you're not allowed to even raise that claim. And this is what the court found to be offensive about the case. This is not Rust versus Sullivan. In Rust versus Sullivan, the government was protecting its own message. Here, the government, there it was a content, here, the government is essentially trying to control a case that a lawyer is bringing. And there's a whole bunch of questions about representation, the lawyer being able to represent and advocate effectively for the client. It has a bad effect on attorneys who might not be able to take cases because they're welfare cases. So the court went in a very different direction in this case, okay? And I think that's the last of our unconstitutional conditions cases. Now we get into the fun stuff, unprotected and less protected speech. You know why this is the fun stuff? It's the fun stuff because a lot of it involves sexual activity, and we get to read swears in cases. A lot of it involves offensive language, okay? So we get to pretend that we're like middle schoolers and kind of blush whenever we see some of this stuff. At the beginning, when we started free speech, I told you that essentially there was protected speech and unprotected speech. The way that we view it is all speech is protected unless it falls into one of the categories of unprotected speech. Here's the list of unprotected speech, meaning the government can freely regulate this type of speech. We're going to have to go on and examine them and determine what constitutes these types of unprotected speech. But if speech falls into one of these categories, the government doesn't protect it. The first is incitement of an illegal activity. So if I incite you to break the law, I can be found guilty of breaking the law myself, okay? An example of this, we'll talk about later on when we do the Chemerinsky case, is during the Vietnam War, a lot of people burned their draft cards, and that was in violation of a law that required you to carry your draft card on your person if you are a young man of draft age. I literally had to carry my draft card in my wallet with me when I went out in public, and there it stayed until it eventually wore out, essentially. These days, you guys don't get, if you're men, you don't get student loans unless you register for the draft. You get to do it online, and there's a permanent record, so you don't have to carry a draft card around with you. A famous guy, a famous pediatrician named Benjamin Spock, and he is not the Spock from Star Trek, but he was probably the most world-renowned pediatrician. He wrote books on how to raise kids. He got arrested and convicted for encouraging young men to burn their draft cards. And so he claimed that he was exercising his free speech activities, and the court said his case did not go up to the Supreme Court. The court said, no, you are inciting an illegal activity, and that is not protected speech. The second one, which is hardly ever enforced, are fighting words. Sticks and stones may break my bones, but names will never hurt me. The Supreme Court has never believed that, okay? Actually, it kind of does, and we'll see why when we get there. This is sort of a hollow one because the court has real trouble finding that this type of speech is unprotected, as we'll see when we get there. There's really only one case where the Supreme Court has said fighting words are unprotected speech, the so-called hostile audience case that we'll talk about later on. And then there's obscenity. This is our first foray into sex-based speech. Obscenity is extreme speech. We have a horrible definition that is hard to figure out, but we'll lay it out and talk about it because you have to know it. Most of the sexual-based material that people become exposed to, including on the internet, is not obscenity. Most of it is plain pornography. Pornography is protected speech. It's got to rise to a very high level of obscenity in order to be unprotected speech, okay? However, even though it is not obscenity, child pornography is unprotected speech. And we'll talk about this later on as well. Child pornography is when, it's kind of the opposite of obscenity. The whole notion of obscenity is to protect the viewer or the reader or the listener of obscene materials. In child pornography, a child under the age of 18 has to be used in the portrayal of sex. The child himself or herself must actually be shown engaging in real or simulated sex. And why is it the opposite of pornography? Because here we are not trying to protect the viewer, we are trying to protect the children themselves who are being used as the actors and actresses, okay, essentially. Child pornography, even though regular pornography is protected speech, child pornography is not protected speech. And again, it's for the welfare of the children. It's to protect the children from the psychological and physical harm that might come to them as a result in engaging in these activities. Let's start with incitement. Here we're going to use the so-called clear and present danger test. Now, your book has a whole bunch of cases that are basically there for historical reasons. I cover those cases in First Amendment law, the various phases that you go through when it comes to incitement. And we'll see that back, in the first Red Scare, there were an awful lot of people who were convicted and went to jail for a very long time for engaging in incitement to overthrow the United States. So if someone would give a speech on socialism or communism, they would be thrown into jail. And the Supreme Court would be saying, well, you're inciting the overthrow of the government. That's illegal conduct. What you're about to get is the so-called Brandenburg test, Brandenburg versus Ohio. It's the first case out of the box in just a minute, okay? That has the current standard. Now, a lot of the Supreme Court justices want to change this standard, but it hasn't been changed. It is the law as we speak. It is the so-called clear and present danger test. More importantly, the modern version of the clear and present danger test. Here it is. Inciting illegal conduct can only be punished when there is a clear and present danger that the speech will lead to. Notice that I have highlighted the word imminent illegal conduct, and the speech is directed to causing imminent illegality. So abstract teachings or general discussions are not enough to constitute incitement. And we'll see this in some of the cases. The court will allow, I've mentioned previously that they'll allow the jacket with the words "fuck the draft" put onto them. A lot of offensive speech. These cases allow cross burning on the lawns of African American people, and they say that is not incitement or a so-called true threat that we'll talk about later on with fighting words, okay? So, you know, the word imminent is important here. And our case of Brandenburg leads us straight to that, Brandenburg versus Ohio. Real sweet guy, Clarence Brandenburg, great guy, leader of a local KKK outfit in rural Ohio, okay? And not only is he like not ashamed of his activity, I don't know why they have to cover their faces. This guy seemed proud of it. What he decides to do is, you guys understand that Cincinnati is in Southern Ohio, is essentially the South.
Yeah.
The airport for Cincinnati is in Kentucky, okay? So what he does is he calls up a television reporter and says, hey, come on down and film our activities. I think you're gonna like what you see. And the rest of the slide kind of shows what is seen, right? You know, men in robes and hoods, some carrying firearms. They burn a cross, they make speeches, they yell out all kinds of offensive words. They butcher the English language. I've never heard of the word revengeance before, but what have you. And then they say, hey, on July 4th, maybe what we should do, didn't mean to move that, maybe what we should do is march on Washington and complain that the president's Congress and the Supreme Court continues to suppress the white Caucasian race, okay? So, you know, this guy's got a scoop, and he goes and he reports it. And Ohio has this old anti-syndicalism law, which says that it's against the law to advocate the duty, necessity, or propriety of crime, sabotage, violence, or other unlawful methods of terrorism as a means of accomplishing industrial or political reform, involuntarily assembling with any society, group, or assemblage of persons formed to teach or advocate the doctrines of criminal syndicalism. And Brandenburg is charged with a crime under this statute. Case goes to the Supreme Court, and the Supreme Court says, no, this is not a crime. This is unconstitutional. He was engaging in protected speech. This is not incitement. And again, here's your test. I believe in repetition. You're going to have to learn this test for the exam. Speech can be prohibited if it is directed at inciting or producing imminent lawless action and is likely to incite or produce such action. Here, Brandenburg and his cohorts were, you know, talking more abstractly, and they were not imminently going forward and engaging in illegal conduct or inciting others to engage in illegal conduct. Okay. Holder, much more recent version of it, and this is sort of suggesting some of the judges, I think, would like to get rid of the clear and present danger case in some of the concurring opinions here. Holder versus Humanitarian Law Project from 2010. Holder was the Attorney General at the time. The Attorney General's job is to defend any cases that are brought trying to strike down federal laws. So there's this Anti-Terrorism and Effective Death Penalty Act. It authorizes the Secretary of State to designate a group as a foreign terrorist organization. And you guys know this. Makes it a crime for anyone to provide material support or resources to even the non-violent activities of a designated organization. So there are two groups at issue in this case that have been put on this foreign terrorist list. One is the PKK, which is the Kurdistan Workers' Party, and the other are the Tamil Tigers, the LTTE, Liberation Tigers of Tamil Eelam. They engage in both lawful activities and terrorist activities, just like the Taliban did. You know how the Taliban came to power in Afghanistan? It essentially opened up schools, provided food and sustenance for the Afghans after Russia withdrew from the war that Russia had been, the USSR had been waging in Afghanistan. And so the Taliban, you know, if someone feeds you, if someone's willing to educate you, you tend to sometimes overlook the fact that they're also engaging in terrorist activities, right? And you know, it's sort of the same thing that's going on here, is that these groups actually do some charitable work, some educational work, some you know, providing sustenance to people, but they also engage in terrorist activities. And they're claiming that people should be able to make donations to or support the non-terrorist side of these groups. And the Supreme Court, and they say, you know, our First Amendment rights are being violated for you not doing that. Supreme Court says, nope, this is not protected activity. This is terrorism. And I think, you know, the difference here is if you apply the Brandenburg test strictly, you know, you're probably going to have a problem with the imminent word, right? The educational part of these organizations are not imminently inciting illegal acts. It's the terrorist side that is. But I think the Supreme Court has taken a more current view of what terrorism is. After all, you guys know that, you know, one of the big notions of terrorism is the so-called sleeper cell. So right now in the United States, there are probably, you know, foreign terrorists who are in this country lawfully, who are in a sleeper cell waiting to get notified to do another attack on the country, essentially. So I think the court believes there should be a, you know, sort of an updated version of incitement. Three dissenters, Breyer, Ginsburg, and Sotomayor, they say, look, just because someone engages in criminal activity doesn't mean that you can't support the non-criminal part of it. That's not really incitement, is what they're saying. Okay. Multiple choice question. This might be near the end of the class for us, as we get into true threats and fighting words next. I was hoping to get through all of the slides today, but we're going to come a little bit short. I think you're going to find this one to be an easy one. It's based off of a real case. The Union of Solid Americans, the USA, is a nativist organization dedicated to the eradication of illegal immigration in the United States. Its leader, Jerry Swanson, recently delivered a speech saying, "If I had it my way, the fence we build along the border will be electric." He followed the comment by saying that such a fence would create some tasty fajitas and refried beans. Pretty offensive stuff. He closed his speech with the following words: "Although I'm a law-abiding citizen, the time may come when law-abiding citizens may have to take back our country from the illegals by any means necessary, including deadly force." Swanson was arrested and charged with violating a state law, making it a crime to, quote, "advocate the duty, necessity, or propriety of violence as a means of accomplishing political reform." Swanson has claimed the state law violates his free speech rights. The court should rule for A, Swanson because his speech was political. B, Swanson because his speech did not include a call for imminent illegal acts. C, the state because his speech posed a clear and present danger of lawless action. D, the state because advocacy of violence is not protected by the free speech clause of the First Amendment. Okay. A, Swanson because his speech was political. Political speech can still incite unlawful activity. Under the Brandenburg test, if it's imminent unlawful activity, then it would be unprotected speech. Okay. So even though we tend to say political speech is the highest form of speech, it doesn't mean that it can't be put into an unprotected context. B looks pretty good under the Brandenburg test, which is our current law, doesn't it? Swanson, because his speech did not call for imminent illegal acts. I mean, in fact, what does he say here? He says, the time may come. He's not saying, let's go out, and kill some illegal immigrants. He's saying the time may come. So this is more in the abstract, non-imminent category than imminent speech. So B looks pretty good to me right now. C, the state, because his speech posed a clear and present danger of lawless action. Well, Brandenburg is still the law and imminence is required, okay? I think the Holder case would suggest that if Swanson was, say, a Timothy McVeigh or a foreign terrorist, you know who Timothy McVeigh was, right? The Oklahoma City bomber, domestic terrorism. The whole notion of terrorism has kind of put the word imminent into a different context, I think is what the court might be heading towards, but we're not quite there yet, okay? But this guy is not really a terrorist in the same sense. D, the state, because advocacy of violence is not protected by the free speech clause of the First Amendment. It is if it's not imminent. We're gonna do the RAV versus City of St. Paul case and the Black versus Virginia case, which were about cross burnings. And if you know anything about the history of cross burnings, they are advocating violence. And in both those cases, the speech is deemed not to be true threats and deemed to be protected speech. Okay. All right, folks. We will see you on Thursday as we wind towards the end of the semester.
You ever seen the movie?
I've seen parts of it. I've never seen the whole thing.
Yeah, there's the one scene where the guy's like, "These guys are creating a fire with crops." Like,